Good afternoon and welcome to our June ChemCareers presentation, all about patents. I'm not going to be doing much in this webinar today. We're going to have a presentation from Tom Turner and Katy Pellow from Abel and Imray. They're going to run the session. There will be opportunity at the end to go through some questions. There is a large number of you listening in today, which is absolutely fantastic, but obviously that does mean that we might not get through all of your questions. So do sort of type those in as we're going through, and I'll try and endeavour to get through a few of those towards the end of the session. So I'm going to pass over to Tom, who's going to start the presentation. So let me just and Tom, over to you.
Great, thank you very much, Laura. Could you, hopefully that is showing the right screen, you're seeing the slides?
Yeah, we can see that, yeah.
Okay, so thank you, Laura, for having us on to contribute to the RSC's webinar series. Today's talk, we're going to be providing a bit of an introduction to patents. We're going to be thinking about what are patents, when do you consider them when you're working in chemical research, and how do you go about getting one. So in our talk, we're going to just give a little bit of an overview of what we're going to cover. We'll start with some introductions, so us, and then a bit of background on patents before we move on to using a bit of a case study on how to identify a patentable invention, using that to think about when you'd be thinking about patenting, before finishing off with a few comments on freedom to operate and what you'd be thinking about in asserting your own patents. We'll have a quick summary and then hopefully a chance for some questions at the end. So introductions first. Well, I'm here speaking on behalf of Abel and Imray. We're a UK-based firm of patent and trademark attorneys with offices in London, Bath and Cardiff. In our work, we represent clients before the UK Intellectual Property Office, so that's in UK patents, UK designs, UK trademarks. Also at the European Patent Office and the European Union Intellectual Property Office. The latter handles designs, industrial designs and trademarks across the European Union. For IP rights outside of the UK and Europe, we work with a network of local attorneys. So that means that we can instruct a local US patent attorney or Canadian, Chinese, etc. to act as representatives before those national offices. And our day-to-day work is made up mainly of drafting, filing and prosecuting patent applications. And prosecuting in this context means getting a patent application through to being a granted patent, and Katy will cover that a little bit later on. Alongside that, a big part of our work is providing advice on infringement and validity, so that might be whether a third party is infringing one of our clients' rights or if our client is concerned about infringing someone else's. And part and parcel of that is whether or not that IP right is valid. So that's us. Now for me, I'm Tom Turner. I'm a partner at Abel and Imray. I'm a European and UK patent attorney. That means that I act before the European Patent Office and also the UK Intellectual Property Office. I'm based in our Cardiff office, although that is a little bit of a notional idea now that we're all working from home and have been since March. But anyway, my home is in South Wales. Prior to joining Abel and Imray, I completed a MChem degree at the University of Durham before moving down to Bristol to undertake a PhD. This being a chemical audience, it's a rare occasion I get to use the full title of my PhD thesis. So my studies were in bifunctional unsymmetrical ditopic ligands for alkene methoxycarbonylation. But since being a patent attorney, my work's a bit broader than that. So I cover a lot of industrial chemistry, that's my main focus, and so that includes petrochemical work, refinery processes, polymers, polymer formulations, and then catalysis going with that. So that'll be heterogeneous and homogeneous catalysis. Outside of that sort of harder chemistry, I do a bit of work in the food technology area. So that'll be food products themselves, but also manufacturing processes, packaging systems, that kind of thing. And totally different to chemistry, I handle a fairly big portfolio of work relating to data centers. So these are large warehouses full of computers, which could be more accurately thought about as a very big machine than a building. And their design and operation has a lot of technical details in it. I'm joined today for this talk by my colleague Katy, and I'll let her introduce herself now.
Thank you, Tom. So, as Tom said, I'm Katy. I'm a trainee patent attorney and I'm based in our Bath office. So I started working at Abel and Imray in early 2018. It takes approximately 4 to 5 years to qualify as both a UK and European patent attorney. So I'm about halfway through that process. Before I started working as a trainee patent attorney, I did my MChem degree at Cardiff University. And then, like Tom, I made the move over to the University of Bristol for my PhD. My PhD thesis title was Catalytic Upgrading of Bioethanol to Advanced Biofuels. So I worked in the area of homogeneous catalysis. I did a lot of ligand design, making catalysts, and then using them to make biofuels. So my patent work touches on similar areas to Tom. I also do some work in the pharmaceutical sector. And my day-to-day work is primarily drafting patents and also prosecution. So as Tom said, that's getting a patent through to grant. And I also assist in giving freedom to operate opinions and also some opposition work. So I'll now hand back to Tom, who's going to give an introduction to patents.
Okay, thanks, Katy. So starting from the beginning then, what are patents? Well, they're intellectual property rights that are granted by a government to afford protection for that intellectual property. This means they're territorial. They are only effective in the territory of the office providing the right. That's generally national, although there are some regional offices like the European Patent Office. And these rights are time limited. That's pretty harmonized around the world now. It's 20 years from the date of filing, and once the patent has run out, it's run out and everyone's free to use it. The underlying principle behind the patent system is it's meant to be there as a promoter of innovation. That's part of its role. And the deal here is that an inventor, in exchange for telling everybody how their invention works, is then given this monopoly protection for it. And monopoly protection is quite powerful. That means that even if someone else came up with the same idea later on, if they were slow to file their patent application, then unfortunately the person that got there first is the person that gets the rights. But as I say, this deal is time limited. So once that patent has expired, the rest of the world is then free to use it. And that's the principle behind the system. So why might you want to file a patent application in the first place? Well, I said already that patents are there to provide some protection, given that monopoly right allows you to protect your technology. Quite often, people will be working for relatively small, medium-sized companies, particularly if they're, breaking into a market for the first time, and it's going to be necessary to get some investors on board to help with that progression. And it tends to be a bit easier to convince investors to part with their cash if they can see that there's some protection in place and there isn't going to be some competitor sweep in and use all that technology for free later on. Patents can also highlight the status of an individual or a company as an innovator. Companies with large patent portfolios are quite often seen as innovative, and even for a small company, just having 1 or 2 patents can actually stand you apart from your competitors. Aside from being a right that you can use to go after someone that is actually copying what you're doing or sort of infringing on your area, patents can be a deterrent in their own right. Once you've got a patent or a patent pending, you can mark that on the products that you're selling. And even if that doesn't stop a competitor trying to encroach into your space, it might at least slow them down. It's quite likely to slow them down, and that might buy you enough time to get established in the market and take that advantage. Slightly duller side of this is using patents to define what is yours, which IP belongs to you if you get involved in a joint venture. Again, for smaller startup companies, quite often need to find a partner. Making sure everybody knows who owns which IP is really quite important in those kind of things. So getting a patent application on file before that starts makes it very clear where that knowledge came from in the first place. And finally, then I've got listed bargaining power. So this is really thinking about interrelation with competitors. It's quite common in a lot of technical areas to be coming up against competitors that are working in a similar area, and maybe they have their own patents which are going to be problematic for your freedom to operate. And if you're looking at needing to get a license from another party, if you've got your own intellectual property, which actually they might quite like a license to, that's a much nicer negotiating position than just having to ask for a license and having nothing to offer in return. So that's why you might want to file. I'll hand over to Katy now, who's going to cover what makes an invention patentable.
Thanks, Tom. So there's 3 key requirements that you need to have a patentable invention. So your invention needs to be novel, it needs to be inventive, and you also need to be able to sufficiently disclose it in your patent application. So starting with novelty, this means that your invention must be different over anything already known. So it could be that you've synthesized a new molecule, in which case that new molecule would be novel. Or maybe you've developed a new synthetic route to a known molecule. In that situation, the molecule itself is already known, but your new route is novel and therefore could be patentable. Novelty is a relatively low bar, so you're just looking for any difference over what's already been done before. So when you assess your invention, dates are really, really important. So when you file a patent application, you get what's called a date of filing, and then your invention is assessed against anything publicly disclosed anywhere in the world before that date of filing. And we call those disclosures prior art. So your invention needs to be novel, and it will also need to be inventive over that prior art. And it's important to note it's not the date that you came up with your invention, it is that date that you actually filed your patent application that's important. So moving on to inventiveness. So your invention is inventive if it's not an obvious modification or combination of the prior art. So we often talk about this being an inventive step rather than an inventive leap. So you don't need to be going into a completely new field in order to meet this requirement. And it is quite a complex legal argument of whether you have an inventive invention. It's a bit more complex than novelty, but essentially you're looking for some kind of advantage. So it might be that you've made something in high yield or selectivity. Perhaps you've come up with a treatment for a particular disease. Basically, you're looking for something that's better over an existing product or method. And we often talk about this in context of solving a technical problem. So if you're solving some kind of problem, then that's a really good indicator that you can meet this inventive requirement. And finally, we have sufficient disclosure. So this is when the skilled person, so that's someone who works in a similar area to that of your invention, must be able to work the invention based on what you've disclosed in your patent application. So when you draft a patent application, it's really important to provide enough evidence in support of the invention. So we like to put in lots of examples and plenty of experimental data to make sure that we are meeting this requirement for sufficient disclosure. And Tom touched on earlier the reasons why this requirement is there, and it's essentially because the patent system works on a trade-off between a proprietor being granted a 20-year monopoly right, and in exchange, that proprietor needs to disclose how their invention works, the idea being that the wider scientific community can benefit from that development in technology. So, what can you actually protect with a patent? Well, the things that you can claim as yours are products and processes. So products could be things like molecules having a certain structure, it could be compositions or catalysts, or perhaps devices or an apparatus. You can also protect processes. So these are any kinds of methods. So it might be a method of making or operating something, or perhaps it could be a use of a product in a particular process. So really you can get a very broad range of protection, and you can cover a wide variety of inventions. So I'm going to hand back now to Tom, who's going to go through a case study on explaining how to actually spot whether you have an invention.
Thanks, Katie. So I'm going to try and illustrate this point about what you'd be looking for in an invention with a sort of chemical example here. And so this slide is providing a little bit of background information. So, you know, a patentability of an invention is always assessed in the context of what's gone before. And so that's what we're considering here. So I'd like you to sort of put yourself in the shoes of a researcher, and ChemCareers is a competitor company. So what we've got here is ChemCareers. They've made this discovery of an alternative route to making methyl methacrylate. So methyl methacrylate is the monomer used to make acrylic plastics. So it's a pretty sought after material. And traditionally, it's been made by a process sort of first developed in the early part of the 20th century. It does make MMA quite successfully and quite cheaply, but it makes a large amount of byproduct at the same time, and the byproduct is contaminated with cyanide residue. So it's not a particularly environmentally friendly process. ChemCareers have come up with this alternative route to methyl methacrylate, and their route is shown at the bottom of this slide. So this is a route that goes via an intermediate, which I've called MEP, that's methyl propionate down at the bottom. And so their route, what's really important about it is this first step. This first step is a methoxycarbonylation step where ethylene and carbon monoxide reacted in the presence of methanol and a strong acid with a catalyst. And that gives you this methyl propionate. And so this is key. The follow-on step is a relatively straightforward chemistry. It's reaction with formaldehyde condensation to give you methyl methacrylate. And the discovery of ChemCareers here was that when they used this particular diphosphine labeled as L1 in their catalyst, so this is a diphosphine with this silyl backbone and T-butyl groups on each phosphorus, so that's bulky electron donating groups on each phosphorus with palladium, then they are able to make MEP, and then that gives them the transformation they're looking for. So that's the background to this. So what have you been doing as the researcher in this situation? So you're working for a company that also quite fancy making MMA and wonder if there's some improvement to what ChemCareers have come up with. So you thought you'd try some different catalysts, see what happens. And the first thing you thought you'd have a go at was something with a diphosphine, similar in overall sort of shape and structure, but with some very different groups on each phosphorus center. So you're trying it with L2 on my slide there. And so that the difference there is you've got these phenyl substituents on the phosphorus, a bit less bulky, not anywhere near so electron donating, and that changes the characteristic of the catalyst. You tried it with that, and actually it doesn't give you methyl propionate, it makes a polymer instead. So that first methoxycarbonylation step actually results in making polyketone. That's not what you're after, so that's not a particularly good result. But you know, being a chemical researcher, you thought you'd try something else, and you had you thought it'd be interesting to see what would happen if you took the hybrid of these two catalysts. So that's L3 on the right-hand side, and this difference here is we've still got T-butyl groups on one of the phosphoruses, but we've now got phenols on the other. So it's the combination of L1 and L2 in many ways. The surprising result from this test is that actually it does make methyl propionate, and even better, it makes it with better purity than the previous method. So it's an improvement as well as an interesting result. That's your discovery then. So when it comes to thinking about identifying something patentable and what you might want to protect as intellectual property, this is where we start to think about scoping out the invention. And what that requires is working out exactly what the invention is and sort of what is the minimum requirement there. And we've got a few different things feeding into this, and this process tends to be a case of looking at the minimal part of it and then broadening out depending what you find there already. And we said before, the requirement for patentability is something new, and then is it inventive? Does it solve a technical problem? And we can approach this at different levels. So first of all, we could look at our new diphosphine we've made here. Well, is it new, first of all? And that would be a literature search. So maybe this is an entirely new a diphosphine? If it is, have we solved a technical problem? Well, we're able to make this methyl propionate in higher purity when we use that diphosphine in a catalyst. So there's your technical problem. But it might not be new. Maybe someone has made this diphosphine before and done something totally different with it. So even if that wasn't new, well, maybe a catalyst including that diphosphine is new. So maybe we could be thinking about the combination of this L3 with palladium. Does that give you something new? And again, that's a literature search, a structure search. Is it out there already or not? If it is new, then does it solve a technical problem? Well, it's the same technical problem. It's making MEP in higher purity. But maybe a catalyst with that ligand is already known. Perhaps it's been used in a different catalytic process. So then you might step back up and say, okay, well, is just the use of this diphosphine in making MEP known or not? If it was already known, that would cast a little bit of question over your research project. So let's hope that wasn't known. And again, we've got a solution to a technical problem. So this is a sort of process of identifying what is new as a starting point. And once you've kind of got that core of the invention, then it's time to think about, well, what's really essential here? What do we need to get this technical solution? So what's required to make MEP? Well, could it be the backbone? Do we have to have this SARL-shaped backbone? Would other backbone shapes work? Could you put substituents on that aromatic ring? Could you make the backbone longer, shorter, less rigid, more rigid, and it still work? And that's going to be some other experiments to try that out. What about the groups on the phosphorus sensors? Seems like the T-butyl groups are quite important because it didn't work at all when we didn't have those. But does it have to be T-butyl? Is it their electron donating or their bulkiness that matters? And could we put anything on the other phosphorus? Does it work with groups other than phenyl? So these are all the kind of surrounding experiments. And what you're looking at here is trying to develop an underlying theory behind your invention. What is it that kind of joins these things together? And that gives us a bit of an idea of how widely we can cast the net when we're trying to claim what the contribution is and so work out the scope of the patent claims. And that final step there, do we have enough information? You might have the beginnings of a theory, but you want to think about where the edges of it are and how widely it can be applied. And what this highlights is the balancing act that comes into play when you're thinking about when do you file a patent application. You don't want to do it too early. If you do it too early, you might not have enough data to support your invention being broader than just one specific compound, one specific catalyst. And if you get forced into focusing down on that one specific species that you've actually made, then your competitors might be able to encroach there. They might find that they could make some subtle variations, be outside of your patent and essentially free to use your invention. But equally, not too late. You've got to stay ahead of your competitors. They might be working on this as well. ChemCareers in this example were pretty active and they might be developing it. And if they get their patent application in first, then that could be tough luck for you. Equally, the final point in there is it is very, very important that you don't disclose your invention before filing a patent application. That is going to be fatal for getting rights around most of the world. And so there's always a temptation as a researcher to get out there and get things published in posters and all that kind of thing. But if there might be some intellectual property to protect, then that needs to be thought about and done at an earlier stage. So I'll hand over to Katy now, who's going to think about the practicalities of getting a patent.
So this is to give you a general idea of how you go about getting patent protection. And this is a general strategy. There are other strategies that you could use, but this one is applicable to the majority of our clients. So first of all, you need to draft a patent application. And then once that's been done, you file the application usually in the UK first. You file it at the UK Patent Office. This then means you get your really important date of filing. The UK Patent Office will then do a search to uncover prior art that's relevant to your invention, and they'll report this to the applicant. And this gives an initial idea of how much prior art is out there and how likely you are to get a granted patent with the scope of protection that you want. Then within 12 months from that first filing, you need to decide whether you want to file applications abroad. So the 12-month period is really important because provided you file your applications abroad within that 12-month period, then they will benefit from the filing date of the first UK application that you filed. So if there's been any intermediate disclosures between that first UK filing and any later foreign filings, either by yourself or a third party, that will not count as prior art against your invention. So if you want to file applications in a number of countries abroad, one of the best options is to file an international application. So this is best thought of as a bundle of options. So it keeps the door open to patent protection in 153 different countries. So it covers pretty much everywhere of interest in the world, except perhaps Taiwan, but you've got cover for Europe, for America, for Canada, and for Australia. So once you've filed your international application for our UK and European-based clients and for some others, the European Patent Office will then conduct another search, and also they will give a preliminary opinion on the patentability of the invention. So this again gives you more information. You can see how your patent application is likely to progress. Then the next big decision comes at 2.5 years from your initial UK filing. So that's from your filing date. This is when you need to decide actually which countries do I want patent protection in. So I said that the international application is like a bundle of options. So at this 2.5 year stage, that's when you actually need to decide, okay, which countries do I want to seek patent protection in. So at this point, the applications are treated independently by different patent offices in different territories, and different patent offices may do further search, and you essentially enter into a negotiation process with the patent offices to get granted patents. And that process takes between 2 and 4 years. So a major advantage of using the international application route is because it provides you with quite a long time to decide exactly which countries you want protection in. So you have your 2.5 years from your initial UK filing in order to test out the market, and you can make an informed commercial decision on which countries you want to get protection in. There's also a type of application called a divisional application. There's not really enough time today to go into this in much detail, but I just wanted to mention it so that you're aware that it exists. But divisional application is when you split an application into multiple separate applications which cover different aspects of an invention. It's also really important to remember that maintenance fees, or sometimes they're called renewal fees, are payable annually for a patent. And this will apply in the different countries that you have your patent in, and different countries can use different regimes for paying renewal fees and different costs. So it is really important to factor in the cost of maintenance fees when you're deciding which countries you want patent protection in. So now I'm going to hand back to Tom, who's going to discuss the topic of freedom to operate.
Thanks, Katie. So moving on a little bit now to, as Katie said, freedom to operate. What I'm talking about here is your right to perform your invention, or your freedom to perform your invention. And it's important to remember right from the start now that patents aren't there to give the owner the right to use their invention. They're there to give you the right to stop others using it. And that's quite an important distinction, really. Just having a patent on a particular product doesn't mean that you could market and sell that product without infringing someone else's rights. If someone had, come up with a patent for a broader concept before you improved that and narrowed that down, then for you to make use of that improvement, you're going to need to get permission from that first person. And our case study earlier is a good example of that, where we were refining a discovery from another company. These freedom to operate type searches are a little bit similar to the patentability searches in the sense that we tend to instruct someone to go off and look for patents in a given subject area, and they are carried out at some stage during product development and certainly before launch. You should remember that they are separate though. They're not the same kind of search as a patentability search. They don't focus on the same kinds of areas, and this doesn't have the same sort of assumptions built into it. So a patentability search, which you get from the patent office when you file an application, that is in no way a substitute for freedom to operate searching. This does sound like another one of these sort of legal headaches that can be a bit of a nuisance to get through, but it's worth remembering that having to defend an infringement action, especially if it were against a sort of sophisticated opponent, would be really very costly and hugely distracting for management. So for example, it's sort of the worst end of the scale. A preliminary injunction could be used by a third party to force you at short notice to abandon launch of a product, and that could be very bad for your business, both in terms of cash flow but also reputationally. And so these freedom to operate searches and then analyses, usually by a patent attorney, are there to help businesses to quantify the risk they're exposing themselves to. It's often the case that there's a bit of a grey area with some earlier rights where there are arguments for and against infringement, there's arguments for and against that right being valid. But once you've got that information, the business can decide what level of risk it's comfortable with adopting. So let's use an example then, going back to our previous case study of what we might think about this. So as we said right at the start that ChemCare had their discovery of using this L1 diphosphine in a catalyst to make methyl methacrylate. And so you've come up with your new discovery, but the freedom to operate analysis has revealed that ChemCare have got two key patents around this technology. The first is directed at their diphosphine specifically. So it's not exactly that diphosphine, but it does include this requirement that the diphosphine has to have alkyl substituents on both of the phosphorus centers. Okay, so it's a bit broader than the particular material, but it is limited to alkyls being on both phosphoruses. Now, you might remember that's a bit different to our example where we had alkyls on one and phenyl groups on the other. So we'd probably be okay over that patent. But they also got another patent for the overall process. And so for their overall process, their contribution here really is the recognition of this alternative route that goes via methyl propionate. And so when you're thinking in terms of getting a patent in exchange for that contribution to the art, then this case didn't end up being so limited. In fact, they were able to get pretty broad protection for this process. It covered the use of palladium with any diphosphine catalyst, and so that's more problematic. What does this mean for us with our example? Well, the reality is that ChemCare can stop you practicing your invention. They've got a granted patent to a process that it appears you would be falling inside of if you were to commercialize your discovery. So what are we going to do about it? Well, one thing you can think about is, can you just avoid ChemCare's patent? And then this requires a sort of fairly detailed analysis of the claims of ChemCare's patent and exactly what it says. Is there something in there that is quite limiting on one of these steps? Are there some process conditions that actually you could do something a bit differently and avoid? So is there a way to modify what you're doing to get around it? I'm not going to cover in any more detail than that, but other than to say that you need to be very cautious of this kind of approach. Are you really working around it in a way that is just dodging it? Because you might still be in that grey area of being covered. So to be a bit careful of that. And then another way to look at this is ChemCare's patent valid? So they will have had to get their patent granted by a patent office, but patent offices don't always catch absolutely every document that's out there. So you might have to do your own searching. Can you uncover any documents that actually show that what they've claimed in their process isn't novel, or maybe it's just obvious? So that's one approach to it. If it looks like you can't avoid their patent and it's valid, well, should you be getting a license from them? And there are things to think about here on this. Commercially now, we're talking sort of pragmatic approaches. are ChemCare actually using this technology in the country that you want to operate? Maybe they've only got operations in the US and you want to commercialize this in Europe. They might want to partner in Europe. So that could be quite a positive thing. And right at the end here, we said earlier on about bargaining power. Do you think ChemCare might want to cross-license your technology? You've come up with this new catalyst system and it has this advantage. It makes methyl propionate in greater purity. ChemCare might quite like to make use of your catalyst that improves purity. So perhaps there's a cross-licensing agreement here. You could use the overall process and they could use your catalyst, and that could be split up so that you get the rights for Europe and they carry on in the US, that kind of thing. So I'll finish off our section on freedom to operate there with a little bit of guidance, stressing the point, because this is an important area. Do conduct freedom to operate searching earlier in development. If you do it early enough, there's a better chance you'll be able to find a workaround, and there's a lower likelihood that you're going to be so invested in a particular product or process that you can't get around it. And so the earlier you know about these things, the better. The caveat to that, of course, is that you don't want to do it so early that you don't really know what you plan to do. So it's a bit of a balancing act again, a little bit like filing a patent application. When you are checking these things early, you might find that your own ideas, your own invention develops over time. And so it might be necessary to top up that freedom to operate search, periodically check, is it fit for purpose? Is it covering everything that we really want to do? Freedom to operate searching is expensive, and it becomes especially expensive if you want to cover a lot of territories at once, particularly those with non-English official languages. So one way to address this is to think about which territories are of most interest first, and maybe get the clearance in those countries, and then move on to others later in your business development. Some things not to do. I said don't rely on patentability searches. It's very tempting to use that as a picture of what's out there, but they're not really reliable enough. And if you are looking at third-party rights, best to get a patent attorney involved. Looking at the drawings and the examples of a patent application or a granted patent are very useful for getting a feel for the core of the invention, but the claims are what really matter, and that takes a little bit of practice to understand the full scope of those. So I'll let Katie take over now for a little bit of some comments on enforcement.
So what can you do once you've got a granted patent? Well, you can enforce your patent against a third party that is infringing. So it is important that your patent must be granted in order for you to do this. And the third party doesn't actually need to be copying your invention. They just need to be doing something which is covered by your granted patent. And the things that are covered vary by whether you have protected a product and or a process. So if you have protection for a product, it's an infringing act for a third party without permission to make, sell, use, import or keep that product. And for a process, it's an infringement if a third party without permission uses or offers for use that process. And there's also some protection for the direct product of a process. There's a type of infringement called contributory infringement, and this is where a third party might not be supplying the invention as a whole, not the whole invention, but they are knowingly supplying an essential element of the invention. So an essential element is something which is needed to make the invention work. So if a third party is providing that element and they know that it's for putting into effect the invention, then that's contributory infringement. There are some exceptions to infringement. So the most common ones are for private and non-commercial use, and there's also exceptions for experimental purposes. But on the whole, the things that are on this slide are what are considered to be infringing acts. So if you launch an infringement action, you need to be aware that that third party does have a number of defences. So it could be found that the third party isn't in fact infringing your patent. So when you launch an infringement action, the courts will analyse the patent in a lot of detail and they will determine exactly what is covered by your patent. And it could be that they find that what the third party is doing actually doesn't fall within the scope of the patent and therefore isn't an infringement. The third party is also very likely to claim that your patent isn't valid. So the third party will probably do a search for new prior art. So this is prior art that wouldn't have come to light when you were prosecuting your patents. And it might be that your invention lacks novelty or isn't inventive over this prior art. The third party could also claim that your invention isn't sufficiently disclosed. So as I said early on, it really is important to provide enough information in your patent application to enable the invention to be worked, because you don't later down the line want someone to claim that they couldn't put your invention into effect. And ultimately, this could lead to a patent being revoked if you haven't met that requirement. There is a third defense, which is called prior user rights. This is a relatively rare thing to happen, but it's when a third party have secretly been using the invention before the patent was filed. So it has to be done in secret, because if that third party was using the invention before the patent was filed, then that's publicly available and so will be prior art, and that later patent wouldn't be new and inventive over what that third party have already been doing. So provided that the third party were secretly using the invention before the patent filing date, they may be allowed to continue to do what they were already doing. So that finishes off our brief overview of patents. So I'm going to hand back to Tom, who's going to summarise what we've talked about this afternoon.
Great, thanks, Katie. That just leaves me to wrap up with a couple of sort of assorted points here. The first one, that reminder that the deal is the patent system. The inventor's getting this 20-year period of exclusivity in exchange for explaining how their novel and inventive technology actually works. That's the underlying principle. If you are working on something new and you've got any ambitions at all on commercialization, do go and speak to a patent attorney or a friendly bunch. We can help you through that complicated looking procedure of scoping out an invention, and we're always happy to speak to people initially to give them that sort of bit of a feel on what their options might be next. So have those conversations before writing things off. Remember that patents are territorial. This can be quite expensive for applicants, because if you want to get rights in lots of countries, that's going to start becoming costly quite quickly. But the other side is that you might find yourself free to use an invention in a particular country because the owner of the patent portfolio might not have been interested in it. So that's the two sides to that part of it. And I said at the end the importance of freedom to operate. If you are looking at launching something new, do consider freedom to operate. Again, speak to an attorney, we can help you out through those things. So that brings us to the end of our slides here and what we wanted to talk about. I'd be very pleased to take any questions. I think Laura might round off with some comments from the RSC first of all.
Brilliant, thank you, Tom. We've had quite a few questions coming in. I'm sort of trying to sort of capture those as we've gone through. So like I said, apologies if I don't get through everybody's, but I will try and get through a few in the last few minutes or so. So a question that's come through quite a lot has been around sort of costs involved in terms of sort of patenting ideas, sort of average costs in terms of obtaining the patent, and then obviously protecting it. Perhaps you could answer sort of questions around that.
Yes, okay. So not wanting to dodge that too much, costs depend very heavily on sort of how widely you want to get protection, and it can also be quite influenced by how complex the technology is. But to give a bit of a feel for things, if you're looking the early stage costs, so that would be drafting and filing a UK patent application to particular invention in the chemical area, so it's not going to be sort of super straightforward, but assuming it's not hugely complicated either, you might be looking, we would sort of say costs of between £6,000 and £8,000. That's to get your application drafted by a patent attorney and then filed. that gives you that sort of first date, that first filing date. And the biggest component in that cost is the professional time taken by the attorney writing a patent application. And the reason it takes quite a lot of time is you really can't add much more to a patent application once it's been filed, certainly once you get past that first 12-month period Katy mentioned. And so everything has to be in there from the start. You have to provide yourself with enough room to maneuver if you need to change things during prosecution, and the invention has to be fully described. So that takes quite a lot of time to write, and that's why it's a fairly significant cost. Then the costs start to vary a lot then on where you go with it next. You could think that 12 months later, if you wanted to get an international application on file, you'd be looking in the sort of £4,500 kind of bracket to then file an international application. That's another big cost, and the reason that's a big cost is largely because actually the official fees are quite high for an international patent application. The UK office only charges a couple of £100 for filing fees, but an international application will be a few £1,000s. And that's then taking you through roughly to about 2.5 years in. And this is a point where it really diverges on costs. So you'd be looking at thousands of pounds per country or region at the end of that stage. But by then, hopefully 2.5 years in, you have a better picture commercially where you're going. And that would help inform your decision on which countries you want to get protection in and how much money to spend on things. So you can see these costs go up quite a lot, and it can easily run into tens of thousands of pounds for protection in quite a few countries for a significant invention.
Brilliant, thank you. Had some questions here around sort of academic researchers and why they might want to, you know, why might an academic researcher want to apply for a patent, and then can they then sort of publish in a academic journal after that? And I guess on the sort of flip side of that, someone asking if they publish in a journal, is there then no hopes of patenting?
That's a really good question on what academics should be thinking about here. And I think it's become more important to universities to get some commercial value out of their research. That's to your audience whether they think that's a good idea or not, but that is becoming more of a focus over time. And so that can drive one side of it. And the other side is it's also not that uncommon for academics to consider starting some kind of spin-out company to commercialize things themselves. And if there is any commercial aspect to this, then really patent protection is something you need to think about. If you don't have it, there is very little you can do to stop someone else making use of your invention, unless you're going to keep it totally secret as a trade secret the whole time. So that comes down to the individual really on whether they want to seek patent protection or not. Most universities, probably all universities, have a tech transfer office which can give some advice on the university's policy on patenting and also some guidance on whether that's going to be paid for. My PhD was part sponsored by an industrial partner, and so patent applications did come out of that, but that was paid for by the industrial sponsor who also owned the intellectual property. And ownership's quite an important thing to think about, and it's quite complicated for academics. It comes down to the kind of employment agreement between the university and the academic in part. So that's your question on why you might want to patent things as an academic. And you said about publishing in a journal. Well, the strict requirement is that for an invention to be patentable, it has to be new and not obvious. And that means not disclosed publicly anywhere in the world, written or orally in any language, before the date the application is filed. So publication is going to be, yes, a disaster for patenting. Except for the one small exception is the US does have a grace period of about a year, but that is just the US, and you do need to know what you're doing if you're going to try and benefit from that.
Brilliant, thank you. Lots of questions coming in now, so I'm just going to get through a couple more. if someone here asking if a patent is later found to be invalid, for example, there was some prior arts that the Patent Office didn't see, would the Patent Office have sort of liability for that?
No, the Patent Office don't have liability. They conduct searches in good faith to the best of their ability, and if they don't see something, that's unfortunate, they don't see it. Once a patent has been granted, if someone feels that it's invalid, it's really up to them to show that it's invalid. So there is no liability there. There are different mechanisms for getting rid of an invalid patent, and that I'm going to assume that's of interest to the person asking the question, so I'll cover that briefly. When a European patent is granted, that starts a 9-month period in which anybody can come along and oppose it. So any third party can oppose grant of a European patent on the basis that the claimed invention isn't new, or it's obvious, it's not sufficiently disclosed, some formal deficiencies, and in contentious areas that's not particularly uncommon. We handle a fair amount of opposition work, and that effectively then starts what we call an inter partes procedure. So the opponent gets to come and make their arguments, and the patent owner gets to make arguments in reply, and there are 3 possible outcomes from that. 1, the opposition is just rejected, the patent stays that it is. The alternative extreme is that the patent is revoked, and so then it's as if it were never granted, and that is effective across all of the European states that the patent covered. Or the intermediate position is that the patent owner is able to make some amendment which narrows the patent down a bit and allows it to stay in force, and that could be a win for both sides in the sense that the opponent might have cleared the way for what they were interested in, and the patentee gets to keep their patent. Or it might be a loss for both sides, another way of looking at it. So that's the European system, and that process is handled by the European Patent Office. That's judged by a division of 3 opposition examiners. In the UK, there are a couple of different ways of getting rid of patents. You can wait until you're sued and counter sue for invalidity as part of your defence, and in much the same way, it's the same kind of point. If a patent is found by the court to be lacking novelty or to be obvious, then it will be revoked, and that is sort of immediately effective. The whole infringement problem goes away. You can also apply to the UK Intellectual Property Office for what's called a Patent Office opinion. So you can submit as a third party at any time arguments as to why the patent is invalid. And if the Patent Office agrees with you, they may then start proceedings to revoke the patent, at which stage the patent owner gets an opportunity to protest. Or they might decide that actually your arguments are not convincing and they uphold the patent. And there are similar kinds of procedures in other countries as well, which I won't go into.
Brilliant. Just, I guess, one more sort of technical question, and then I've had quite a few questions around becoming a patent attorney and how they do that. But someone here is asking what can result in abandonment of a patent filing, and can it be granted in some countries and not in others?
So the first part, what can result in, what can cause abandonment? So you can decide at any stage that you don't want to carry on with a patent application if it is no longer commercially important, or in some cases, if it's just not possible to get it granted. That does happen. When you're filing an application, you never really know what's already out there, and it may turn out that what you've come up with isn't new, and in that case, you just won't be able to get a useful patent out of it, and you may decide to draw a line under it. The second question there was, can you get different situations in different countries? And the answer is absolutely yes. Once the patent sort of split off into these different countries, if it's an international bundle and they're handled separately, they take on a life of their own. And the different offices do have different approaches to examining certain aspects of the law. Inventiveness is a really good example there. The US Patent Office takes quite a different approach on inventiveness to the European Patent Office, and the outcome of that can be that a case ends up being abandoned in one office. It can just be that a patent gets granted with different scope in the US to what it's been granted as in Europe, and that's not a problem. from a legal point of view. It might be a problem for the owner and for third parties, but there is no issue with patents having different scope in different countries. And another way that this can come up is if there's a conflict between two patents that were pending at approximately the same time, that conflict might be localized to just the country in which those two cases are filed, and so that can also cause you to have some difference between countries.
Brilliant, thank you, Tom. Like I said, just to finish off, we've had quite a few questions coming through about how you apply to be a patent attorney, kind of what background you need, whether you need to have a PhD, and also a specific one for Katy in terms of how she's found that transition from being at university, doing a PhD, and then becoming a trainee patent attorney. So just, yes, I guess some general advice around becoming a patent attorney, because a few people have been interested in that.
Katy, I'll let you answer all of those.
Okay, thanks, Tom. So there's a few things that were asked there, but yes, you need a technical background, and no, you do not need to have a PhD. So you need to have an undergraduate degree in, well, in our case, chemistry, but any technical field, engineering, physics, chemistry, and a PhD isn't necessary to go into a career as a patent attorney. Then I would advise people, if they are looking for jobs as a trainee, there's two good websites. So there's IP Careers, and there's also CIPA's website. So CIPA are the Chartered Institute of Patent Attorneys. So there you will find advertisement for trainee patent attorney jobs. So it is very much a on-the-job learning process. There's kind of two sides to it, really. You're learning about how to be a patent attorney on the job, and then there's also your formal training requirements. You have to pass some exams. So on the day-to-day job side, you're employed by, it can either be you go for a job in-house at a company to be a patent attorney, or like ours, we aren't working for one client, we work for lots of different clients. And there you start doing the job from day one. You work on cases, you get to meet clients, and you are supervised by qualified attorneys who will train you. Then on the more formal side of your training, you have to pass exams. So to be a UK qualified attorney, there are some foundation exams. You can either do the foundation exams, or a lot of trainee attorneys go down the route of going on a university course. So I actually went to Queen Mary University and did a course, and that exempts me from doing the foundation exams. Then there are some UK final exams, which you take typically 2 to 3 years into your training, and then once you've passed those, you become UK qualified. On the European side, so the vast majority of patent attorneys are both UK and European qualified. So there are some requirements in how long you've been in training before you're allowed to sit the exams. So it's at the 2-year point, you take what we call a preliminary exam, and once you've passed that, you have to have been in training for 3 years, and then you're allowed to take the European qualifying exams, and once you've passed that, that's when you become European qualified. So I think I was also asked what the transition is like from going from a university background into the career. It's certainly quite different. So I did go straight from my PhD into the job as a trainee patent attorney. There's lots to learn. It's a challenge, but it is exciting. I think having my chemical background was really useful. You get really involved in what the inventions are, and I'd say that felt like the easiest part when I first went into the job, because that's what I was familiar with. But then there is plenty of learning the law, which is a little bit more challenging. But like I said, you are supervised by qualified attorneys who help you through that process. So hopefully that covers most of what was asked.
Yeah, that's brilliant. Thank you, Katie. So like I say, I haven't got through everybody's questions, but hopefully the presentation has given you a good flavour there. Thank you to Tom and Katie for their time today. That's been absolutely fantastic. Just to finish off, just to remind all of you that are listening in terms of support that you can get from the RSC, so really thinking about sort of career and professional development services that you could get from me or my colleagues. We offer one-to-one consultations, guidance with CVs, applications, interviews, and also general support around your professional development and thinking about your professional development. We also offer a mentoring scheme which is open to our members, and obviously by being part of the RSC there's lots of opportunities to network, and there's lots on our web pages as well. So you know, for those of you that are members, you know, do remember that we are there and can support you. And if you're not yet a member, then obviously do consider thinking about that, not just in terms of the career development support, but also thinking about sort of professional recognition, such as chartered status, and again thinking about the connections that you get through the sort of networks that are events that are organised by our interest groups or sort of geographically across the globe. So like I say, thank you all for tuning in today. Thank you all for your questions. Thank you, Tom and Katie, for your time today. And thank you all for listening in. So thank you very much.